Good afternoon, everyone. Welcome to this week's edition of Trump Trials and Tribulations. We will let folks trickle in for a moment, and then we will get started. Okay, I've had enough silence for now. Let's get started, though it is a pretty quiet week. Everything is shut down entirely in DC. Everything is shut down entirely in Fulton County, and everything is shut down entirely in New York. So we are left with Southern District of Florida, where there's a little bit going on. So Anna, can you bring us up to speed?
Yeah, so we've had two developments in the past week in the Southern District of Florida in Judge Eileen Cannon's courtroom. One is that pretty soon after the ruling in the Supreme Court's decision in Trump's DC case on the immunity issue, Trump's team in the Southern District of Florida filed a motion in which they basically wanted to file supplemental authority and briefing based on the Supreme Court's immunity ruling. They said that there were two reasons for that. One is that they've already filed a presidential immunity ruling in the classified documents case. They wanted to be able to basically use the Supreme Court's ruling and kind of make further argument as to why that motion should be granted. But then they also wanted to provide further supplemental authority based on Justice Thomas's concurring opinion in the case, which relates to the argument that Trump has raised about why special counsel Jack Smith is allegedly unlawfully appointed and used a funding stream that is also unlawful. Remember, we've talked over the past 2 weeks about why that concurring opinion is relevant to that argument. So I won't really go over it in much detail here, but those are the two kind of substantive matters of authority that they wanted to raise with Judge Cannon and have further briefing on. But they also said that as a result, they wanted certain aspects of the case to be stayed, as particularly a bunch of the pending SEPA litigation deadlines. And we heard from Judge Cannon this week in which she temporarily granted these requests to suspend some of the deadlines. Basically, she kind of is putting off these deadlines until there can be a round of briefing on this motion from Trump to stay the case, and then also to have further supplemental briefing on the immunity issue. So, Natalie, to make it clear, this is briefing on whether there should be further briefing. It is not actually substantive briefing on the immunity question. And how long did Judge Cannon give the parties to do this, do you think?
15 years.
Well, no, it's more like I think that the standard time, she made a comment in the paperless order, something to the effect of, given the special counsel's request that that they be given the normal amount of time in all matters of, in all briefing matters or something to that effect. Basically, she's going to give them 2 weeks. And then there's also a reply that is allowed for Trump's team after that. And so I think that for the time that it will take all of this to be briefed, it'll be July 21st. Who knows if Judge Cannon will hold an evidentiary hearing on whether to have more supplemental briefing. Stay tuned. But that is the first thing that we had a development on. The second thing, and to Judge Cannon's credit, she was working the weekend of the July 4th holiday weekend. I think it was like a Saturday that I got a docket alert, and lo and behold, Judge Cannon has denied Walt Nauta's motion to dismiss the charges based on selective and vindictive prosecution. It was a very short order in which she basically said Nauta has not met the very high standard that has been set out in the case law for showing animus in the prosecution. And she basically said, and keep in mind that this is a motion that related to that episode in which Stanley Woodward, Nauta's attorney, claimed that special counsel's office, Jay Bratt, had made some kind of comment to him of, oh, I didn't think that you were a Trump a guy, and then also made another comment about a judgeship that he was up for. That was what had been alleged, at least. The special counsel's office had a very different version of events. Judge Cannon basically says, I'm not going to, really accept either side's version of the story, but I will just say that even if it was true as alleged by the defense, then it still wouldn't rise to the level to allow me to grant relief for selective and vindictive prosecution. So, however, she did say in that order at the very towards the end of it that this should not be construed in any way as, speaking to the merits of Trump's own selective and vindictive prosecution motion. That motion is still pending before Judge Cannon. So we had some developments in Florida, but that is pretty much it.
All right. Ben, anything to add on Florida?
No, that's a pretty comprehensive account of the action, which mostly amounts, by the way, to announcing inaction, briefing on whether inaction should occur. I have nothing to add to it.
All right.
I mean, Ben, I do have a question for you, Ben. I think one of the arguments that they're making here about why all of this the immunity stuff should be dealt with before anything else in the case is because of this idea that the Supreme Court has said basically the prosecution can't go further until these immunity claims are litigated. It seems to me that probably Judge Cannon is going to find that to be appealing, but what do you make of that argument? I mean, do you think it makes sense that she has to deal with all of this first, or can she still be, dealing with some of these other motions at the same time? What do you think under the Supreme Court's ruling makes
Well, first of all, she has no motion before her to deal with this stuff. And so I think there's a very good argument under the Supreme Court's ruling that she needs to deal with it first. She does not need to deal with it sua sponte. And immunity has to be pled. Even a pardon has to be pled. And so, the first thing for her to do is to sit there and do nothing and wait for Trump to file a brief that says, which he will do presently. I mean, his lawyers, these are good lawyers, and even bad lawyers would know to file a brief saying that this Supreme Court decision has implications. So the first thing for her to do is to receive the brief and then set a briefing schedule on his brief. I don't see why you would order briefing on whether to order briefing on. I mean, that just seems like, first of all, making yourself the main character of the story. But secondly, it's not a jurisdictional issue. It's not before the court unbidden by the parties. And so I think the right way to deal with it is exactly the way Justice Merchan did it, which is, the parties come and say, hey, you got to deal with this. And by the way, I don't think the government would resist that she has to deal with it. It's this weird way she is ordering the process of deciding whether to deal with it and when.
Yeah. So one other thing on this point too, not related to the case in the classified documents case, but I will note, although we haven't had any movement actually on the public docket in the court in DC, there was some reporting this week by Hugo Lowell of The Guardian, in which he reported that Trump's team basically intends to try to put off or squash any efforts to have an evidentiary hearing with live witnesses, and that, you know, they're going to try to throw a bunch of wrenches into things when things do get going and the case actually returns to Judge Chutkan by, for example, raising a bunch of executive privilege claims or trying to, I guess, convince witnesses to invoke the speech or debate clause, things to that effect. So that is notable in that there was some reporting on the expected strategy from Trump's team. However, we're still waiting for that case to get back to Judge Chutkan because there is this roughly 30-day waiting period in which the parties have an opportunity to petition the Supreme Court for a rehearing. So that case is not yet back with Judge Chutkan yet.
Right. I mean, I don't think that I have no doubt that there will be a rough and tumble litigation before Judge Chutkan. I just think that it's important, like I took your question to be about the oddity of Judge Cannon's sort of preempting any of it with this weird motions about motions thing. And I just think the normal course of business is, you know, when the mandate gets returned to Judge Chutkan, she will have her orders from the Supreme Court. Judge Cannon does not, by the way. She's the case, the opinion is not directed at her. It's an opinion in a different case. And so somebody has to say, hey, this has the following implications for this case. And look, it does have some implications for this case because the predicate for this case is a set of behaviors that happened in the White House. And there's a reasonable argument under this opinion that some of that activity is not cognizable by her. And so that's going to have to be thrashed out. I just think it's weird of her to do it this way.
Yeah, it is weird to have, you know, a whole cycle of briefing on whether there should be further briefing when clearly there should be. I think that she could go ahead and order the briefing and then say, you know, if you want to file a supplemental brief on the issue of whether I should stay the rest of the case and these other deadlines, then that's fine. It just does seem a bit weird when it's very clear that there's going to have to be further briefing on exactly how she should proceed here.
All right. Well, with that, let us transition over to questions. So I'll just note for folks who are watching us on YouTube, but this is your occasional invitation to join us as material supporters of Lawfare, where you too can submit questions directly to us. And particularly on those weeks where there isn't a lot to go through on updates to the 4 trials we've been covering, we will be spending a good chunk of time answering questions directly from the audience. So if you want to become a material supporter, go to our website and sign up. I am going to start with one of the questions that was submitted in advance and then turn to the folks who have been putting questions into our Q&A. First question, and I'll direct this one to you, Ben. Is there a point in the process of trying to prosecute Trump under the limitations imposed by Trump v. United States, where Jack Smith should abandon the prosecution and focus on reporting out his findings? If that happens, will Trump himself be able to sue to block public release of Jack Smith's report, or will Smith be forced to redact information such as what Mike Pence said about Trump's pressuring of him?
Well, so let's take those questions in reverse order. I don't think there is much chance that Jack Smith is going to abandon these cases. He may be forced, depending on how the courts interpret immunity going forward, he may be forced to abandon the January 6th case. But the body of the Mar-a-Lago case took place after the election and after Trump left office. And so there is some of that case that definitely survives. And in fact, the majority of that case definitely survives. Now, what the cases do not definitely survive is the election. And so I could see a situation in which Jack Smith makes a determination that it's more important to put the full story out after, say, Biden were to lose the election. But I doubt it, honestly. And I think the much likelier possibility is that uh, Jack Smith will force the cases to be dropped and himself to be removed, and will, in the context of that, release whatever information, perhaps in the form of congressional testimony, he thinks it is ethical and proper. Remember, there are grand jury secrecy rules at issue here that are criminal issues to violate. And so he has to dance carefully. But the regs do allow him to write a final report, but most prosecutors don't decide to abandon their cases. And Rachel Maddow has spent a lot of time recently talking about the great O. John Raggi, who abandoned his case against American Nazis and in the late 40s or mid 40s, and then instead issued a report. And was fired for it because he kind of went rogue. I love this story. It's a wonderful story about defying the Justice Department hierarchy in the name of some greater truth, but it's not likely to happen today. The Justice Department hierarchy, it has more norms and rules than it did then. And I don't think Jack Smith is likely to stick his finger up at them in a John Raggi sort of way, electrifying as that would be, particularly because I think, unlike O. John Raggi, he would have to commit crimes in order to do it effectively.
I'll just say I actually see a world in which it is possible that Jack Smith would write a report, because, as you say, Ben, the special counsel regulations allow, and actually at the conclusion of an investigation require the special counsel to write a report explaining his or her decisions. And there's also a separate provision that allows the attorney general to request that the special counsel provide an explanation for any investigative or prosecutorial steps that he or she takes. And so I can imagine a world in which, either the determination is that I'm declining to prosecute because I see no viable path toward prosecution after in the face of the Supreme Court's immunity decision and how it's being applied thus far in the rulings we're seeing by Judge Chutkan, or if Trump does win the election and the administration is coming to a close, that the fact that both the prosecutions and any investigation of them or in service of them would be coming to an end, that it might be a good incentive to write these reports that are really provided for in the regulations.
So there is no doubt that it's provided for. The question is, usually you write the report after you're done with all the prosecutions. And here, the Mar-a-Lago case will, I think Anna will back me up on this, still be pending at the time of a transition to a second Trump administration.
Well, pending unless it is dismissed by Judge Cannon.
But in which case it'll be on appeal.
Yeah.
Right. There will still be a case. And the January 6th case will very likely still be pending because we'll still be trying to figure out which facts in the indictment survive. And so to imagine a report instead of a prosecution, you'd have to imagine that sometime around the election, he realizes, I'm going to get fired and these cases are going to get dismissed, and kind of writes a guerrilla report more or less in secret in the 3 months remaining of the administration, with the idea of going out in a blaze of glory after the cases are dismissed.
I don't think that's, I think that that's a sort of dramatic reading that it doesn't need to be. I think that Smith could reach the conclusion that as the Trump administration is going to take over, he is going to be fired. Therefore, in the time he has remaining, he is declining to prosecute because it's a non-event. It's an impossibility. And therefore, under the regulations, he has to write a report explaining his declination.
And question, to what extent, I mean, will any grand jury material that is included in that report be redacted? What is the...
That is a matter of the discretion of the Attorney General. It is permissible to include grand jury material in the report. In the case of the Mueller investigation, that material was redacted. That was part of Bob Mueller's redactions, Bill Barr's redactions of the thing, but they all eventually came out, I believe. I believe the unredacted report came out. So, one question is how much material is grand jury material? But look, Natalie, I agree with you that it is theoretically possible. I just think it is unlikely, because I think Jack Smith will, in practice, want to hang on to his cases.
All right. Elaine, you have the floor for your question, please. Elaine, are you with us? Okay, I am going to move on to a next question. And Elaine, if you find us again, just drop us a line in the chat. Next question. Did Trump v. United States explicitly or implicitly overturn any of the following cases? There's a long list of cases. Are you ready? United States versus Nixon, Clinton versus Jones, Trump v. Vance, Trump v. Mazars, Trump v. Thompson. The questioner notes Nixon, Clinton, and Trump lost all of these cases. Would they win them today? Anna, do you want to start with any of that list that you would like?
Oh gosh, I'm trying to think. Ben, why don't you start? I mean, there is someone has raised the question of how the case reconciles with Nixon. Ben, I think that you might have thoughts on that. So maybe if we start there, nothing's coming to me necessarily with the other ones, but I think that United States versus Nixon might be one of the more interesting ones.
All right, so let's start with the easy ones. No, it does not overrule Nixon, Clinton v. Jones, because Clinton v. Jones involves pre-presidential conduct and litigation during the presidency, whether you're temporarily immune during your presidency for civil litigation for conduct prior to your presidency. And this is the opposite on all three vectors. It is after your presidency, criminal litigation for conduct during your presidency. So all three dip switches that are ones or zeros in Clinton v. Jones are opposite dip switches here. So I think it is perfectly consistent with Clinton v. Jones to say during your presidency, you are not temporarily immune for in civil litigation for conduct before your presidency, but after your presidency, you are permanently immune in criminal prosecution for conduct during your presidency. In other words, to use the fact pattern in Clinton v. Jones, sorry if this is mildly off color, but you can be sued during your presidency for sexually harassing / assaulting an Arkansas state worker from before your presidency. But if you do the same thing in the White House during your presidency, you cannot be criminally prosecuted after it, or at least if it was in an official meeting, in the context of an official meeting, and it can be reasonably characterized as an official act, you are at least presumptively immune. I think that's the way you would harmonize it, and I think it's reasonably harmonizable. All right, Nixon is a more complicated case because Nixon, first of all, is a grand jury matter. It is a criminal matter. But it is, people forget this, it is not a grand jury subpoena. It is a trial subpoena by the defendants and in the context of the criminal trial of indicted co-conspirator defendants. And so I think if you wanted to harmonize them, you would say, look, Jaworski didn't prosecute Nixon. He prosecuted Haldeman and blah, blah, blah. And in that context, he subpoenaed material from Nixon. Nixon's apparently not immune from the subpoena, but he is immune if Jaworski had actually prosecuted him for those behaviors that others went down for that would be official acts if Nixon had done. For example, the matter in the smoking gun tape involved ordering an investigation by one agency of another agency, right? So those are presumptively immune acts under this. So is there a certain tension there? Yes. Did it overrule it? No.
And what about introducing that evidence, though, from that you received from the subpoena against the individuals who actually were indicted?
So again, tension, but not overruling, because nowhere in Trump v. United States does it say that you cannot use the evidence against somebody else. It says you can't use the evidence against Trump because he is immune. So I think a further case that would say, imagine Jack Smith indicts the 6 unindicted co-conspirators and tries to use evidence that the Supreme Court has barred its use against Trump against, say, Jeffrey Clark or Rudy Giuliani. I don't think that would be in significant tension with Nixon, I think. But I'm not sure that the court here has said anything about evidence being inadmissible against anybody except Trump.
I think that's right. I think some commentators are worried that the logic that the majority puts out there with respect to why prosecutors can't allow the jury to see evidence of any official acts in furtherance of proving charges for unofficial acts, if expanded to other cases, because the logic is it would effectively allow questioning of the president for doing what he's supposed to do under his presidential duties, which would have this terrible chilling effect that is really the basis for, at least the sort of policy basis for granting this sort of immunity to avoid the chilling effects. Personally, I think that's an overread of the opinion. And I think if you read it carefully, that the discussion of evidence is pretty tethered to for purposes of prosecuting the president. But I know other commentators have expressed a concern about extending that logic.
Yeah, so
beyond.
I think if the court extended that logic to that situation, then you would have a real question about the logic of Nixon, which is why, hey, wait a minute, why did you allow the president's personal tapes to be subpoenaed if you wouldn't allow the president's conversations with aides to be used as evidence against those aides? But I think it doesn't, to say that the president is personally immune from criminal indictment for those acts or for having evidence of those acts used against him doesn't necessarily raise the same concerns in and of itself.
Yeah, agreed. And just to finish off answering this question, the same sort of debate applies in the context of Trump v. Vance. That was the case where the New York State subpoena to Mazars was for Trump's tax returns. And this was in connection with the New York State prosecution in connection with the hush money case. And that was really about evidence. Nixon was about process. This was about production of evidence, again, not for the, excuse me, again, not for the purpose of, I'm sorry, I'm having technical difficulties. Can you guys still hear me? Okay, sorry. All right, so I think that we've sort of covered the logic with respect to Vance. Mazars is also relating to a subpoena to also Mazars, also for tax returns. That one was a congressional subpoena, so different set of logic because it's not a criminal prosecution. Still does implicate separation of powers concerns, which the majority in Trump v. United States spends a lot of time on. So, possible that extending the logic with respect to evidence that we just talked about, which for those of you who want to do a close read of the opinion is in part 3C of the opinion. If it's expanded, it may affect those. I think one, very good point that our colleague Quinta Jurasic made to me, though, is both Trump v. Vance and Trump v. Mazars were written by Chief Justice Roberts, who also wrote the majority in Trump v. United States. So unless he meant to overrule himself only a couple of years later, I think we can assume that they are probably not overruled. And I think the last case on that list was Trump v. Thompson, which was the question of whether a former president's assertion of executive privilege could prevail over the incumbent president's waiver of executive privilege. So Ben, do you want to comment on that one?
Yeah, I think that is a profoundly different question. And that's, the question of whose privilege it is, right? A privilege can be waived. So the question, if Anna is my lawyer and I confide something in her in an attorney-client privilege protected situation, there is no doubt that I can waive that privilege in any number of ways, including just by talking about the matter outside of the same matter about our conversations elsewhere. The oddity of the presidency is that the persona of the person holding the privilege changes. So unlike my conversation with my lawyer, Anna Bauer, there's no successor Benjamin Wittes, right? Like every 4 years, somebody else doesn't become me and inherit my privileged relationship with my lawyer. But the presidency does, the presidency holds this privilege and the persona of the president does change. And so Trump v. Thompson is fundamentally about who controls the privilege under those circumstances. And I don't think that is a question that this opinion has any implications for. And the successor, Benjamin Wittes, agrees with me about that. So if either Natalie or Anna or their subsequent personas want to disagree with that, we can have a 6-way conversation about it.
I do not disagree. I'll also just say, as sort of a in the weeds matter, the Supreme Court decision in Trump v. Thompson actually sort of dodged the entire complex question, because the DC Circuit below had said that there wouldn't have been executive privilege anyway, even if Trump had been the president. The DC Circuit then went on to say also a former president's assertion of executive privilege should not prevail over the incumbent president in most circumstances. But the Supreme Court actually went out of its way to say that that was non-binding dicta. So we don't actually, that decision, as it turns out, isn't actually that dispositive of much of anything. But I think Ben is right that it's the matter of executive privilege is quite different than the matter of immunity from criminal prosecution. So let us move on to a question from Mike McNeely. Mike, go ahead, please.
Yeah, I've been thinking about what Jack Smith might do, and I imagine a very small car pulling up to the DC District Court and 4 soon-to-be ex-lawyers tumbling out to go testify. And I wonder if, presuming that he's allowed to do this, which I think he would be, what do you expect him to do in terms of calling witnesses? I think the best witnesses are the people that aren't in the government.
I'm a little confused by the question. When are you talking about?
I'm talking about the mini trial.
Gotcha.
Ben, do you want to take that one in the first instance?
Sure. My guess is that there's going to be initially a fight over how many the mini trial is. Is it? And by the way, the Supreme Court opinion leaves this question kind of open. It's genuinely unclear to me what process they are envisioning. And Natalie and I have been having a protracted, ongoing kind of dialogue. I wouldn't say debate, because I'm not sure we disagree. We're bonded in some degree of confusion about this. So normally in the pretrial context, you assume all the facts in the indictment true. So you don't do any fact gathering, right? You try to argue it on the pleadings. So maybe Jack Smith will say, a la Natalie, what do you mean? This is a pretrial motion. We assume the facts in the indictment as true. And Trump will say, well, assuming the facts in the indictment are true, this is all protected by the Supreme Court opinion. So maybe you don't have any witnesses because you just assume it true. But if that's the case, why do you need to remand it to the district court? The Supreme Court is perfectly capable of reading the same indictment that Judge Chutkan is. So that's possibility number one. And I think in the regularist of the regular order, it's probably the way that makes sense. It's just not the way that makes sense in light of the fact that there's a remand from the Supreme Court to make this judgment about which facts are and are not subject to this immunity. The second possibility is you say, okay, what facts can we all agree are personal conduct? What facts can we all agree are, official conduct? And you say, okay, anything the two-party agrees on, there's no dispute between the parties, where it says that Trump bent down to tie his shoes, that's clearly personal conduct. Where it says he gave a State of the Union address, that's clearly official conduct. Where everybody agrees we're not going to do anything. But where there's a dispute, there's two types of disputes. There's disputes as a matter of law, and there's disputes as a matter of fact. And where there's disputes as a matter of law, we're going to have briefings on the law. And where there's a dispute as a matter of fact, Trump said this to Natalie Orpett because he was trying to do blank, right? No, he wasn't trying to do blank. He was trying to do X, Y, and Z. Where there are disputes of fact, we're going to have to take testimony about that. So that's a second way to think about it. A third way to think about it is, we have to see what the special counsel has on every damn fact in the indictment. And we have to make a judgment about whether, given the evidence he plans to present at trial, whether this fact is a fact that is of an official nature or not. So we're going to take a lot of testimony, we'll see a lot of evidence in order to make threshold judgments about whether this matter should be in the case or not. And I don't know if either of you two disagree with me about this, but I think that there's a lot of discretion in the hands of the district judge about how she wants to think about this.
Yeah, I think that that's right. And I mean, I spoke about it a little bit before, but I think that a somewhat similar context is supremacy clause immunity context. There is examples of district courts holding evidentiary hearings on supremacy clause immunity claims where there are disputed questions of fact, although it is a kind of live question. I think only maybe one circuit court has actually dealt with the question directly of whether you're supposed to take the allegations in the indictment as true, or if you actually, resolve disputed questions of fact if the trial court should do that. Clearly here that has to happen because it's a little bit different from supremacy clause immunity, where, for example, it's unclear if it's an affirmative defense or if it's an actual, immunity from suit. There's some debate in the, academic literature about that. Here, the Supreme Court has been very clear that this is basically, it is a real immunity to not go to trial in the sense that everything has to happen in terms of resolving the immunity question. So I think that certainly favors the idea that if there are disputed questions of fact, there needs to be an evidentiary hearing, potentially with live witnesses. I will also say that although the court is kind of cagey and vague about whether or not it's envisioning a situation in which you're taking the allegations and just kind of looking at them in the indictment, there is this section that I think very much indicates that the court at least has some limited fact finding in mind, and that is on page 30 of the majority's opinion. They're talking about the way that you might look at whether Trump's public communications are official or unofficial, and the court says there, whether the tweets, that speech, and Trump's other communications on January 6th involve official conduct may depend on the content and context of each, knowing, for instance, what else was said contemporaneous to the excerpted communications in the indictment, or who was involved in transmitting the electronic communications and in organizing the rally could be relevant to the classification of each communication. And then they say, and that is a necessarily fact-bound analysis that is best suited to the district court. I don't see how that says it can be read without implying that there needs to be some sort of evidentiary hearing.
Or that she may determine that there needs to be, right?
Right.
I think she has a lot of latitude here.
Absolutely, she does.
If Judge Chutkan wants to say, look, I took briefing from both sides on each and every fact, and I've determined that blank. She might get reversed, but no one's going to stop her from doing that. And on the other hand, if she wants to take detailed testimony based on precisely the matter that Anna just described, the DC Circuit's not going to intervene and issue a writ of mandamus to prevent it.
Yeah, and I think it very well could be a hybrid as well, which I think we've sort of gestured at, but it could be that Judge Chutkan decides that as a legal matter, she can make a determination that certain allegations in the indictment are absolutely not official, they are only unofficial, or even could try to make some distinctions between the what we've sort of previously called the first and second bucket of the decision, which is the two different types of official acts, one of which is the preclusive and conclusive official conduct over which the president has absolute immunity, and the other is sort of all other presidential official acts over which the president has, at a minimum, presumptive immunity. And that sort of thing, at least according to the majority's opinion, can be decided, or at least may be able to be decided as a legal matter with reference to the Youngstown progeny and the sort of case law that exists about the scope of presidential authority and where it's concurrent with Congress and where it's not. So we'll just have to see.
So one more. Oh, sorry. Mike actually has his hand up, I think, maybe, or maybe not. Okay. I thought that you had a follow-up. Sorry, Mike. One question that I have for Ben and Natalie. It's clear that if there is some sort of evidentiary hearing or fact finding, the court certainly seems to have that in mind in terms of the first stage, which is dividing the official from the unofficial conduct. But what about this second stage where you're looking at the separation of powers issues or the effect on the executive branch? Is there any argument that there too there is any fact finding that needs to go on for example, the categories where the court has already said this is official conduct that has presumptive immunity, but we're leaving it to the court to determine whether or not it has any danger of intrusion on the executive branch? What would that look like?
I mean, the short answer is we definitely don't know, and the majority was extremely vague, I think purposefully on this point. It sort of made some comments about how it was perfectly well-established tradition for such uncertain, unprecedented questions to be left to the lower courts in the first instance, blah, blah, blah. I think certainly once you get to the second bucket where you're looking at official conduct that's not in the preclusive and conclusive zone, and you have to deal with the question of the prosecution has to deal with the requirement to rebut the presumptive immunity. I don't know how you do that without some fact finding. I don't know, Ben, if you disagree.
I don't disagree. I also don't I'm not sure what facts are relevant to the inquiry, right? So the inquiry is about whether a presumptive immunity has been overcome, by the way, without reference to the president's motive in taking the step. You're not allowed to consider his motive. Why is not entirely clear to me, but you're not allowed to consider the motive. So the president has taken act X, and it is at least presumptively immune. It may be absolutely immune, but it's at least presumptively immune. And the burden is on you to the prosecution to establish that prosecuting it would not pose any risks to the functioning of the executive branch. And it's not clear what the standard is of that, of establishing that. And by the way, even if you establish it, it may be immune anyway. The Supreme Court isn't telling you just yet. I have no idea what evidence is relevant to that consideration as a factual matter. I do agree, Natalie, that to the extent that there is evidence that either side wants to introduce that is relevant to that, that's got to come in in the inquiry.
Yeah, I mean, sorry, go ahead, Anna.
Oh, no, I was just going to say to Mike Mike, what we're saying, I think, is that we have no idea what the evidentiary hearing might look like because the Supreme Court's decision was very unclear in respect to how things would proceed when it goes back to the trial court.
And it's also because we have no idea what Judge Chutkan's instincts are about what a proper hearing for this. It's not like Judge Cannon, where we've seen her over and over again in motions hearings and other hearings. And so we kind of have a set of instincts about how she is running this case. Remember, Judge Chutkan had like 2 or 3 hearings on relatively ancillary motions. She made one substantial set of rulings, which was or two really, a set of motions to dismiss, and then the motion to dismiss on this basis. And so how she would handle a question like this, I mean, I've certainly watched her over the years in other cases, but nothing really prepares you as a judge for a question like this. And so what she will and won't allow, I really have no idea.
Yeah, I mean, I think one thing we can point to, I mean, I totally agree that we certainly cannot predict it, because I think it really will be up to Judge Chutkan to do the unenviable task of figuring out how, in God's name, to apply this to an actual case. The one thing that I will point to is the majority talks a little bit about one example that it says is a complicated one, right? So it says very little about the specific allegations in terms of its new test and how it would work, other than saying that the allegations with respect to conversations with Justice Department officials, so that's conversations with Jeff Clark to replace the AG, this controversy over sending letters to states to encourage them to convene special sessions, et cetera, that those were not allowed because the president's interactions with the Justice Department are absolutely immune. The example that they gave, that they just said was hard but didn't make any calls on, was conversations that Trump had with Vice President Pence, and said it's complicated because certainly conversations that a president has with his vice president are core presidential authority. I'm paraphrasing here. But the vice president also has this president of the Senate role in connection with electoral vote counts. And so maybe those conversations that are alleged in the indictment related to conversations between a president and a president of the Senate, and maybe those shouldn't be considered within the conclusive and preclusive executive authority. So that is a matter where possibly maybe you could see some sort of fact finding as to in what capacity should we understand Mike Pence to have been in these conversations in the indictment. I mean, as a practical matter, the first thing you're going to do if you're Trump, even if that comes to pass, is say that this is all protected by executive privilege. So who knows? Let us move right along now that we have left you with no clarity whatsoever. Thomas, please go ahead.
Hello, can you hear me? Hello?
We hear you.
Oh, the question has to do with the civil suits, which is where Trump has gotten most of his accountability. The ones going on in DC right now, I wonder if there's any thoughts on that, since they're already in discovery.
Go ahead, Anna.
Yeah. So are you talking about the January 6th cases or something else?
Yes, I think it's Lee versus, I have to look it up. I think it's currently Lee versus Trump.
So I actually haven't been following very closely with the civil cases because we've primarily been focusing on the criminal cases. But Natalie and Ben, are you generally aware of what the latest is in that case? I mean, I know that there has been ongoing discovery, but I'm not sure exactly which stage of the litigation they're in beyond that basic understanding.
Yeah, so
sorry.
There were a series of cases that were consolidated at the DC Circuit under the caption Blassingame, or sometimes Blassingame, depending on how you pronounce the individual's name, which I honestly don't know, so I'm just going to say Blassingame. Trump lost those at the DC Circuit level, and the Supreme Court seemed to be, in this case, fairly tolerant of the standard that the DC Circuit set in Blasingame. It at least didn't say that it was wrong. And so I think we can assume that the Blasingame standard or something like it is fairly stable. I'm not sure about that, but I think it is reasonably assumable. So that's going to mean that a lot of the case has been remanded to the district court, which is Judge Mehta, and a lot of discovery will have to happen before that case goes to trial. Honestly, don't think there is any chance of that being completed before the election. Civil discovery takes a long time. And so I think you should assume that that case is going to putter along for a good long time. And remember, under the Clinton v. Jones decision, will not stop if Trump wins. Unlike the criminal cases, the civil cases will continue. And so, but they move, civil litigation moves at a glacial pace, on the theory that justice delayed is not, in fact, justice denied. It's justice mollassed. And so, I think you can expect that if Trump were to win the election, at some point, you would have, as you did with Clinton in the context of the Paula Jones litigation, you would have a deposition with him. And as that is for Trump when you're president, that's a very dangerous moment because, you get Clinton lied in that deposition and he got himself impeached over it. And Trump does not fare well in depositions, as Robbie Kaplan has shown. And so I think, the civil litigations, they have two major impacts. One is that they're a rip-roaring pain in the ass for Trump. And they cost an enormous amount of money because he does tend to lose them. And, sometimes when you lose a civil litigation, it's a kind of slap on the wrist situation, but sometimes it's a $450 million situation. And so, that's one thing. But the second thing is that when you happen to be president, a litigation that follows you along, if you happen to be a liar, is a very dangerous thing. And that's really the big lesson from the Clinton-Jones litigation. So look for Trump to maybe settle that litigation one way or another if he actually wins. That's what he did with the Trump university litigation.
Okay, I'm going to move to a previously submitted question. I have heard commentators remark that the Constitution includes a speech and debate clause giving legislators some immunity, and if the founders wanted to include presidential immunity in the Constitution, they could have done so, but did not. My question is, where is the limit of judicial interpretation of the Constitution with regard to immunity? If presidential immunity was knowingly left out of the Constitution, did 5 or 6 individuals on the Supreme Court just amend the Constitution outside the usual process for doing so? Anna, you want to take this one?
I mean, it's not just that immunity was not included in the Constitution. It's also that the Constitution, quite actually seems to suggest that a president can be tried for various crimes. So I mean, Ben, you will certainly have thoughts on this. So that's kind of all that I will say for now, other than that. Yes. Can you actually, Natalie, can you read the last part of that question? Because I was kind of stuck on the first part, but I want to just make sure that I got the end of it.
Sure. If presidential immunity was knowingly left out of the Constitution, did 5 or 6 individuals on the Supreme Court just amend the Constitution outside the usual process for doing so?
Oh, well, I mean, look, that is in some sense, that is kind of what happens in judicial decisions about the Constitution, and that just is how judicial review works. The Constitution ends up having different meanings than perhaps it was intended to. And in this case, it certainly seems to have a very different meaning than it was intended to. But I will leave it to Ben to comment his thoughts, because that's all that I will say about that for now.
Yeah, so I agree with Anna with one caveat, which is that there is this hard problem that Congress passes all kinds of laws without thinking about the presidency that would clearly be unconstitutional if applied to the presidency. So, for example, it is a crime to kill an American citizen overseas. The president, when he was Barack Obama, ordered the killing of Anwar al-Awlaki, who was an American overseas, and we zapped him with a drone. Now, a lot of people, a lot of constitutional scholars, including the ones who wrote the OLC opinion on behalf of the legality of that action, believe that that statute would be unconstitutional if applied to the president acting in his capacity as commander-in-chief against a target who was a senior al-Qaeda leader who was planning operations against the United States and posed an imminent threat, right? And so once you say that, you are saying that the president has to be immune from a certain set of presidential, of regular old acts of Congress that were never meant to apply to the presidency, and if you applied them to the presidency, would really prevent the president from doing his job. And so that's where the situation becomes difficult. I do think the situation is difficult. And there are a lot of differences between what I just described and immunity. And one of them is really technical, but it's really important. It's when you get to appeal it, right? So if it's immunity, as we discussed earlier, you have to deal with it before anything else in the trial, because immunity is the right not to be tried at all. It's saying the court has no authority over you. If it's just an unconstitutional application of the statute, you can move to dismiss on that basis. And if you don't win, you go through trial and you say, then you appeal on the basis that the trial was defective because the statute's unconstitutional as applied to me in my role as president. So I think there are important features of the presidency that you need to consider in this context. But look, at the end of the day, it kind of begins and ends for me with the idea that the Constitution says two things about presidential immunity. One is that the president can be tried after impeachment. In other words, after you kick him out of office, he can be tried in the ordinary course of the judicial system. That doesn't sound like immunity to me. The second is the thing that it doesn't say, which is that the president is immune. And that's in sharp contrast to speech and debate clause immunity. Have the courts found other immunities? Yeah. Federal judges are immune for any official act too. I'm not sure that's right, by the way, but you don't look behind the judge's official acts. They're just immune. Federal prosecutors have what's called prosecutorial immunity. So it's not the first immunity that has been sort of discovered. But do I think it's wrong? Yeah, I think it's wrong.
Yeah, and I'll just say one more quick note on this, and then Auntie will turn to you for your question. And that is that the dissent actually spends a lot of time talking about this exact issue that, hey, look, the founders knew how to create immunity. You're putting all of this logic in the rationale of the founding fathers and how they set up our constitutional system, and you're finding something that simply isn't there. But the majority thought that it did, and it explained that in its rationale, which was not in the text of the Constitution, but in sort of the originalist perspective on it. And all of that goes to show that people can read the same sorts of things and come out with very different explanations of what they mean. Auntie, please go ahead.
Thank you. Can you hear me 5x5?
Sure
Yes.
can.
Excellent. So I noted that a couple of days ago, there was a release by two Democratic senators, Wyden and Whitehouse, that they had asked the Attorney General's office to appoint a special prosecutor to look into Justice Thomas's possible ethics and tax law violations, including but not limited to two apparently gifted trips to Russia some 20 years ago, which was nice to hear. I'm wondering if there is, I tend not to prejudge, but from my perspective, I would imagine that there is no chance that the Justice Department lifts a finger to actually investigate these allegations. But I would love to hear your opinion if you think that such an investigation or even appointment of a special prosecutor is in any way, shape, or form realistic. Thank you.
Anna, you have any thoughts on that one?
I'm gonna throw this one to Ben.
I will just say on this that I don't see any evidence that Justice Thomas has committed crimes. And a special prosecutor is appropriate when, and in my judgment, only when, there's a plausible criminal predicate. Now, moreover, I don't see any reason why the Justice Department in the regular course of business can't investigate Justice Thomas itself. I don't think you need a special prosecutor for that. I think an ordinary U.S. attorney's investigation or public corruption section investigation would be fine in that situation. But the more important point is that I don't think that there's any evidence that I've seen anyway of criminal activity. There is evidence of wildly inappropriate activity. And so I actually think, at least with respect to Justice Thomas, not with respect to Justice Alito, the members of the House who introduced impeachment articles are sort of more on the right track, in the sense that this is exactly the conduct that Abe Fortas faced in significant calls for impeachment over, and was ultimately driven from the bench. That is, taking what amount to secret payments from a very rich person. Now, in Justice Thomas's case, the payments come in the form of gifts, not in the form of cash. But I don't really see what the material difference is. This is a very large amount of money that he took in gratuities and did not disclose, as he seems to acknowledge now that he was required to do. And I don't really see what the difference is between that and Abe Fortas. And so I think, in the way that members of the House are always undisciplined, they've thrown in Justice Alito in here, Justice Alito, his crime seems to be that he has a wife who flies flags, and has taken much smaller gifts that are much more in line with what other justices have done. So I don't think the grouping of them together here is helpful. And I don't think the thinking about it in criminal terms makes a lot of sense. But I do think if there's a sort of WTF Justice Thomas thing going on here, I think that's pretty legit. And I do think the traditional way we think about that is the impeachment process, not the criminal investigative process. Now, you know, that people's fervor for that diminishes when, you know, you can't, first of all, don't control the House, and so you're not going to get it done, at least not in this Congress. But secondly, there's no prospect of prevailing in the Senate either way. And so there's a kind of sense of it as fruitless, but I don't think the answer to that is to pretend that it's a criminal matter. I have no idea what the crime that would be supposedly implicated here would be.
Yeah, I agree with all that. I don't have much else to say, but I think the underlying point that a prosecutor is probably not the right vehicle here is one that I agree with. Anna, do you have any other thoughts on that one?
I do not.
Okay. So a question from anonymous attendee, Anna, that I'll pose to you in the first instance. Can't Congress pass a law that removes this newfound immunity and say that the non-immunity is not reviewable by the Supreme Court? This sounds like a con law exam question.
Oh my God, this does. I mean, I think the answer is no, because the immunity derives from the powers of the presidency, and I mean the court claims that it is from the Constitution itself, and so no, Congress could not override the Supreme Court's decision in that way.
Well, I will agree with that with one caveat, and then I will, for which I will cite a
Oh no,
precedent.
did I just fail the con law exam?
No, you didn't fail the con law exam, but I do want to raise an issue that will be close to the heart of one Natalie Orpett. So the one area in the question is a sophisticated one because it is in two parts. The first part of which New York Bureau, aka Anna Bauer, addressed. The second part of which she did not, which is whether Congress could just say, hey, we're limiting the Supreme Court's appellate jurisdiction, so we're doing this unconstitutional thing of overturning a Supreme Court ruling on a matter of core executive function, and you can't do anything about it because we're depriving you of jurisdiction. And I will say that that is reminiscent of something that Congress did in, say 2004, 5, with respect to Guantanamo detainees. They didn't like the Supreme Court's ruling in with respect to jurisdiction over habeas cases from Guantanamo. And so they said, we're stripping the court. Not only are we overturning this and passing the Military Commissions Act and all that, but we're stripping the court of jurisdiction to hear the question. So you don't get to call it unconstitutional. And the Supreme Court said basically, sorry, we know it says in the Constitution that, you know, you can limit our appellate jurisdiction, but we get to decide when you get to do that, so fuck you. And that was basically it's the first section of Boumediene, and I can promise you that nothing will make the conservatives, all of whom dissented from that section of Boumediene, nothing will make them happier than to stuff it back in the liberals' faces, though none of the liberals and almost none of the conservatives were on the court then. They will stuff it back in their faces real hard in order to say precisely what Anna just said on the merits. And by the way, they will be right on the merits, whether they're right on the jurisdictional matter or not.
All right, let us move to another question. This is from Jeff M. Have Supreme Court decisions this term, Trump v. United States, Loper Bright, arrogated too much power to the judiciary, would Congress restricting the Supreme Court's appellate jurisdiction be a remedy? Which is a bit reminiscent of what we just discussed. If not, what is? Anna, thoughts on this one?
I mean, Ben, you clearly have thoughts on this one, so why don't you take this one?
So look, the Supreme Court, Congress has the constitutional authority to limit the Supreme Court's appellate jurisdiction. It is something that Congress has not historically done very much because it's kind of a nuclear weapon. And usually the better way to deal with a Supreme Court that is out of step with the electorate has been to win elections and let the actuarial tables do their work. And that would be the preferable way to deal with it now too, in my opinion. There's a problem with that, of course, which is, the polls. But we are not really a political site or podcast or live stream, so I'm not really going to talk about that. I will say that same problem makes it very hard to contemplate jurisdiction stripping provisions. Right now, Republicans control the House. They're very likely to control the Senate after the election. They may control the House and the presidency as well. And under those circumstances, there is no chance of a jurisdiction stripping provision passing. And so the question is largely hypothetical. If you entertain the hypothetical and say, would jurisdiction stripping be an effective instrument? The answer is it would be an effective instrument if the courts would tolerate your doing it. What they showed in Boumediene, in my opinion, is that they are not especially tolerant of the Congress stripping their jurisdiction of matters that they really want to hear.
All right. We have several more questions. We're going to do our best to get to as many of them as we can, but we are going to wrap up by 6:30. Let's go to apologies. Let's do a sort of meta question here. Anna, I'll turn to you first. In the Trump v. United States presidential immunity case, why did SCOTUS majority paint a broad rule for the ages? That's a quote from oral argument from Justice Gorsuch, rather than stick to the facts of Trump's indictment and just call balls and strikes? It appears the conservative/originalist/textualists were legislating from the bench. Anna, what do you think?
I mean, I don't know the answer to this question. I can't see into the minds of the justices as much as with this decision. I really wish that I could, because it might actually shed some light on how to read the opinion. But I think that, there maybe are a few ways of looking at it. One is that maybe what the justices are telling themselves here is that this is a rule for the ages, in the sense that they are trying to write this in a way that is protective of future administrations that might be focused on, for example, retaliation or retribution against former presidents like Joe Biden or President Obama. I think that could be one of the kind of psychological elements to what potentially a majority, as particularly people like John Roberts, the writer of the opinion, is telling himself in writing this opinion, instead of writing something that is much more narrowly confined. So there could be that. But then I think there might be different psychological motivations for other individuals in the majority. Again, I don't want to cast aspersions about those psychological motivations, but I mean, I will point out that For example, it is very interesting to me that Clarence Thomas wrote an entire concurring opinion that is on the very topic of a totally different kind of.
We seem to have
think Anna
lost
froze.
Anna, but I will finish her sentence for her. That Clarence Thomas wrote an entire concurring opinion that is about a matter that is actually pending in front of Judge Cannon right now. And are you back?
Oh, did I go out? Sorry.
Yeah, you went out for a while, so I
Oh, no.
decided to finish your sentence.
Sorry. Go ahead.
Did I finish it accurately?
No, I don't know. I just came back, so I have no idea what I heard. Judge Cannon, that was it.
Yeah, I said, you blinked out right after you said that Justice Thomas wrote an entire concurring opinion that was, and then you blinked out. So I said that was directed at a matter that is currently pending before Judge Cannon right now.
Right. It seemed, very, again, directed at what's going on in that prosecution. And so I think that you could also read some aspects of this opinion. Again, that is separate from the majority opinion, but you could read that as a kind of, maybe what's going on here is that Justice Thomas is setting out some kind of roadmap for the defense, or excuse me, for Judge Cannon down in a totally separate Trump case. And so it's, there seems to be something that's going on there that is very different from the situation that might be going on in someone like Chief Justice Roberts' mind, that is maybe more focused in on a rule for the ages, in the sense that you're thinking about a future administration that might be more focused on retribution, retaliation against the current administration or previous administrations. So I think that there's like a few things that are going on here. And again, I don't know what actually is going on in the minds of the justices as to why they chose to write this. But Ben, I'm curious if you have further thoughts other than those two very speculative kind of motivations that I just set out in terms of why write a very sprawling opinion like this.
Yeah, I mean, look, we often talk about the Supreme Court as though it's an it, or the majority is an it, and it's not, it's a they. Unlike the presidency, it's not a unitary actor. And different justices have different motives, and sometimes they spell them out pretty clearly, and often they don't and probably shouldn't. And I do think, from their opinions, Justice Barrett's motives and thinking is quite different from Justice Thomas's. What's animating her is very different, and frankly, from my point of view, more interesting. But I really don't believe in spending a lot of time going behind the text that justices write. I do think, the courts are a unique body in that they have to show their work about everything. And I find the psychoanalysis of justices to be, first of all, impossible, and secondly, uninteresting. And I don't choose to spend time on their motives. I do choose to spend time on the inconsistencies in their publicly expressed views. And so when a justice writes one set of principles in one opinion and then contradicts them in another opinion, I think that's very worth pointing out. But I don't try to spend a lot of time in their heads. And in my experience, honestly, dealing with them personally, and I have, dealt with a lot of them a lot over the years. I I don't find that most people's psychoanalysis of them comports very well with my observations. And so I'm reluctant to do it myself because when I see other people do it, it often just seems wrong. So I don't know the answer to the question, and I will say I think you have to evaluate every justice as an individual, and you can adjust and you can evaluate the center of gravity of the liberal wing and the center of gravity of the court and the center of gravity of the conservative wing. But Sam Alito and Amy Coney Barrett and Brett Kavanaugh, they're really different from one another. And to blur those differences by saying, well, they all signed Dobbs, so they're all the same, spreads. I mean, it is true that they all signed Dobbs, but that's the overlap of a very complicated Venn diagram.
But I would say I would really like a Jodi Kantor, who's the writer for the New York Times, who wrote the kind of investigative story about how Dobbs came together. I would love to read that story about how this opinion came together and
right. But the interesting thing about the Dobbs case story is that it wasn't about what's going on in justices' individual heads, right? And
what I mean is
bring me facts about how this opinion came together, and I'll gobble them up.
Which is very different from what is the kind of psychoanalysis. It's more of what was the deal making that was going on between the justices. I will read that in a heartbeat, and I can't wait to read it, whoever writes it.
Yeah, I'll just add one thing. I agree with the general sentiment. I don't think there's much to be gained from the psychoanalysis. I do think it's interesting to note that there is a conversation on this exact topic going on between the majority, Justice Barrett's concurrence, and the dissents. And Justice Barrett's concurrence says, she signs on to the opinion and she does what I consider to be great diplomatic maneuvers to portray what I think are really differences between her approach and the majority, as I read the majority to say this when I would argue that's not what they said. And she is saying that, but she's choosing to make it sound harmonious. And one of the key divergences is on the question of whether the court could have made some specific rulings as to this exact indictment. And that is something that the dissents also thought that the majority did wrong. So it is sort of interesting in this, how did the deal come together? How did the opinions get written the way that they did vein to think, why was it that Justice Barrett formulated her opinion, which sort of shared a perspective with the dissents, as a concurrence? And why did the majority decide not to sign on with those aspects of Justice Barrett's concurrence that spoke to this precise issue?
Yeah, and I think it actually speaks a lot to that she did portray it as a concurring opinion as opposed to a dissenting or a dissenting in part opinion, when it really had the kind of tenor more of a dissent of sorts. I think is telling, and it's also in some ways might reveal that potentially the kind of motivation for doing that, and again, not trying to speculate about what those motivations were, but it may be that Justice Barrett sees her concurring opinion as a potential kind of gloss on the majority opinion, that people will read her concurring opinion as and kind of view that majority opinion eventually maybe through the eyes of her concurrence, if that makes sense. And so I think that there is potentially some kind of strategizing that you might be able to glean from the decision to, it's a concurring in part opinion as opposed to dissenting in part.
Agreed. Okay, well, unfortunately, we are at time, so we are going to have to leave it there. But we will see whether there is more to discuss on updates from these 4 cases next week. And if not, then we will be very happy to answer more questions from all of you. Thank you so much for joining us.